Good morning, everyone. I would like to welcome you to today's webinar, where we'll be dissecting the Data Protection Act. My name is James Olubai. I'm Executive Director at Zamara, and I'm with a number of my colleagues who will introduce themselves at the appropriate time when they will be speaking. I am delighted to welcome all of you to today's webinar on a crucial topic that affects our organizations handling personal data in Kenya, the Kenya Data Protection Act, and how to ensure compliance with it. In our increasingly digital and interconnected world, the protection of personal data has become a part of paramount concern. The Kenya Data Protection Act, which my colleagues will be putting it in short, the DPA, which came into force in 2019, 25th November 2019 to be precise, is a significant milestone in safeguarding the privacy and security of personal information and data. It provides a legal framework for the collection, processing, and storage of personal data while imposing very strict obligations on organizations that handle this sensitive information and data. Today, we have gathered here to dive deep into the intricacies of this legislation, to understand its implications for our various businesses and for individuals alike, and most importantly, to explore how your organization can navigate the complexities of compliance. Throughout our webinar, we will cover a number of topics. However, the following will be quite essential for us to note. Firstly, we'll run through the overview of the Kenya Data Protection Act. We will discuss the key principles and provisions of the Act, ensuring that you have a solid foundation of understanding of the DPA. The second item is on compliance, the requirements around compliance. We will delve into the obligations placed on data controllers and data processors. Remember that data controllers and data processors are defined specifically in the Data Protection Act, as well as the rights of the data subjects being the individuals whose data we handle. And we'll also explore how to meet these requirements and comply with the Act effectively. The third item is an insight into the services that we, Zamara, can provide in this space. Your questions and insights are very vital, and we encourage active participation, and you can continue putting your questions on the chat as we progress the discussions. By the end of this webinar, our aim is for you to leave with a comprehensive understanding of the Kenya Data Protection Act and a clear roadmap to ensure your organization's compliance. Compliance is not only a legal necessity, but also a means to gain trust and enhance your reputation among customers, your partners, and all your stakeholders. Without further ado, I would like us to begin exploring the DPA and the path to compliance. Once again, thank you for being here. And I would like to hand over now to my colleague, Shruti Shah, who will take over from me, and then she'll introduce some of our other colleagues that will also be taking you through this particular webinar. Thank you.
Thank you very much, James. It's a pleasure to have you here. My name is Shruti, and I work for Zamara. I'm an actuary by profession, but in the last few years, I've been exploring in the data space, specifically data protection. There was a lot of questions we were receiving about the Act, and we felt like it would be vital to bring everyone together to go through the Act and to tackle some of the challenges and confusions around the space to see how we can all comply. I think one of the things as we kick off the webinar is that I want you to ask you not to have negative preconceptions about the Act. I know that we're living in a time of never-ending statutory compliance, and it feels like we're all drowning in it. But our aim today is to educate you on the Act and how to comply with it. And we're hoping that we'll put a positive spin on data protection, because at the end of the day, it has great value for individuals like you and me. For a lot of people, data protection is optional. It's an inconvenience, a burden, and a barrier. But if we see it as a condition to good business practices, a framework for the fair treatment of people, and an enabler of innovation, then there's a lot that we can get from it. The aim of the Act is to ensure people are treated fairly and lawfully, protecting them from the harms that can arise from their personal data being misused. Data protection legislation, like the KDPA, provides the legal framework and protection for people and their data, recognizing that it matters how people are treated. I'd now like to welcome my colleague, Jane Lucy Mwangi, who will take you through the introduction to the Act.
I'm going to share my screen.
There's a few raised hands. If you've got any questions, please, you can put them in the chat box, and we'll also be having a Q&A session at the end.
So kindly confirm that you're able to view my screen. Okay, thank you. So I'll move on to the Act. So I'll start with what is data protection. What comes to your mind when you hear data protection? Generally, data protection refers to a set of practices, policies, and measures designed to safeguard personal info and safeguard sensitive data from unauthorized access. So I'm going to give you a brief summary of the Act. So the Act was enacted on 8th November 2019, but it was put to effect on 2021, and registration started 2022, 4th July to be specific. The Act has given effect to the Article 31C and D, which states our freedom of privacy. That's my freedom and your freedom of privacy. So the Act also was able to establish the Office of the Data Protection Commissioner, that acts as a regulatory that is able to ensure that my data, my personal data, and your personal data is safeguarded well. Also, the Act has enabled to ensure the regulation of the processing of personal data. That is how much of personal data is collected and how much of that data is put into practice. Also, the purpose of collecting the data. Also, the Act was able to provide the rights of data subjects and obligations of data controllers and data processors. Some of these rights include, I as a data subject, you as a data subject, you are able to go and request for your data from maybe a data controller or a processor, and that data controller or processor is obliged to give you your data. Also, the Act was able to put effect the Article 35 of the Constitution that gives you and I a right to erasure and deletion of your personal data. Move on to my next slide. So who needs to register? This has also been a hot topic because most of the people don't know who needs to register and the processes of also registering. So we have a data controller and a data processor. So the definition terms, my colleague Shruti will dive into them, but generally, data controller is a person who controls an individual's personal data. That is a data subject. Like a data controller, for example, in this case being Zamara. Zamara is a data controller in the sense that it collects individuals' data. That is my name, your name, for example, telephone number, emails, addresses. All those are your personal data. Also, Zamara is also a data processor. For example, it operates as a third party, whereby it has been given the mandate by a data controller, a different data controller, for example, to handle each individual's personal data. So in this case, who needs to register? Any company that has a turnover of more than 5 million Kenya shillings needs to ensure that it is registered, and also for any organization with more than 10 employees. Also, the registration fee varies it's from 4,000 to up to 40,000, whereby the fees is determined by the annual turnover of the organization, the number of employees, if the entity is a public organization, or whether the organization is a non-profit making entity. For example, if an entity has an annual turnover of 5 million, less than 5 million, and has employees who are less than 10, that means it should pay 4,000 for registration. Moving on to my next slide, I'll talk about the purpose of the Act. So the Act was generally put into place to ensure that my personal data and your personal data is safe. That is generally to protect me and you. And it protects us in the following ways. It ensures that the processing of personal data over personal data subject is guided by the principles. Shruti will dial more on the principles, but I can talk about two, where the principles involve accuracy and there's data minimization. What do I mean by this? So I mean, for example, in the essence of you may walk into an organization and they request some of your personal data. You're obliged to ask the purpose of that data. And for example, you're also obliged to actually not share some of your personal data if you feel it's not relevant for that certain role or for the reason as to why you are giving them your personal data. Also, the Act protects privacy individuals. I believe it has been a hot topic out here. Also, we have had so many people and complaints about invasion of privacy in terms of maybe social media, people's names leaking, photos, or even maybe you find anonymous numbers which tend to send messages to your phones and you don't know how they even got to either your number or even your name. So the Act comes in place to ensure that your privacy is protected. And in such a scenario, you can actually go and complain to the authority of which that's now the Office of the Data Protection Commissioner, and your rights can be able to be put into place. Also, the Act, we have said that the purpose of it was also to establish the Office of the Data Protection Commissioner, which works for us because we have a place where we can go and be able to raise complaints in case of any invasion of privacy of which we have a right to do so. So we have regulates processing of personal data. This comes in place where organizations are advised to only collect the data that they require. So they can only collect the data they require and they cannot collect the data they do not require. Also, it provides for the rights of data subjects. We have seen the Act has tried has put to effect the Article 31 C and D, of which it's a freedom of our privacy, in which the Act is able to protect that. Also, we have us as data subjects, we have the right to ask for deletion of our data, on which the Act actually supports us in that. Also, finally, we have obligations of data controllers and processors. So under this, the Act also is able to clearly identify the obligations data controllers and processors need to put in place to ensure that your data and my data it is well taken care of. Also clearly states the measures that needs to be put in place to ensure that personal data and any sensitive data is put in place. Also, recently we have had consumers and vendors, even international organizations, they have become more attached to the data protection and the data privacy. And most of them, we find that they want to ensure that before they get into business with you, or even before they have a go ahead to maybe hire your company to do something, or even you have to hire a company to do something, they have to ensure that you are registered, you're compliant with the ODPC by having a registration certificate that shows you are a data controller or a processor, which gives them the comfort of being sure that their individuals' personal data and also the data for their members is safe with you as an organization. So I'll hand over to Shruti, my colleague, who is going to proceed on the presentation. Thank you.
Good morning once again. So I'm back here to tell you that actually, if you do embrace the Act, there's a lot of business advantages, right? People are more likely to trust you. You're going to have a better reputation. You'll have better and improved information governance. And also your relationships are empowered because you'll have clear roles, responsibilities, mandates, and expectations. We often look at it as a very tick box exercise, but rather than that, it's important to embrace it and embed it into your culture. Going further, looking after data well assists you in performing your organization's tasks and functions well. If you're using your customers, suppliers, staff, service providers, members, or anyone's personal data to do something for your organization, you need to be sure that you're using that the data you're using and doing so securely, accurately, it's fit for purpose, and has been obtained and used legally. I'll take you through some of these principles and some of the bases of data protection. The world is changing fast. One important change continues to be the role of data. We keep hearing this. Data is the new oil, and we can make good use of it and extract great potential from it. But we are both in our personal and professional lives immersed in data, and it influences us in ways we are aware and also sometimes ways that we are not aware. It can inform us and empower us when used well, and it can exploit us and disempower us when used badly. I'll now take you through some of the definitions in the Act, some of the principles, and the lawful basis. What is personal data? Personal data has a very, very broad and wide definition. It is basically any information that enables you to identify a person. And there's some obvious ones, like someone's name, their photo, email address, mobile number, bank details. But there's other less obvious ones. Your KRA PIN number, your NSSF number, your NHIF number, your IP address. But this is all personal data. And within the personal data category, there's a subcategory, sensitive personal data. And essentially, this is data revealing a person's race, religion, health status, genetic data, biometric data, marital status, sex or sexual orientation. And basically, if this data, sensitive data, gets misused, it could really cause a lot of harm and destroy someone's career, someone's relationship, and someone's life if misused quite badly. And there have been instances around the world. I'm sure we all know people who've had an attempt at being hacked. Someone's WhatsApp has been hacked. whether it's your own or someone you know. But looking at this list, I'm sure you can think of the different types of data that your organization processes, and it needs to process this data for it to be able to provide the services. Next, I want to talk to you about processing. Now, as an actuary, often processing can mean very complicated actuarial valuations, but actually in the Act, the Data Protection Act, processing is a lot of things. It is essentially the full data life cycle, from cradle to grave. So when you collect the data, you record it, you organize it, you structure it, or you store it, and you might adapt it or alter it. You might go back and retrieve it or use it for some purpose. You might need to disclose it to a third party. And at some point, you might need to erase it or destroy it. This is all considered processing, and this all comes under the Data Protection Act. There are three key players, and Jane Lucy already introduced them in the data protection space. A data subject is an identified or an identifiable natural person. You and me, we're both data subjects. A data controller determines the purpose of the data processing, the means and the purpose. And often, some of this data processing will be outsourced to a data processor. So a data processor acts on the instructions of a data controller, and it is essential that there's a written agreement between a data controller and a data processor. Now, both the data controller and the data processor need to comply with the Act. Generally, the bigger responsibility lies with the data controller, but that doesn't mean that both parties don't need to comply. Everyone needs to comply. Some companies will also have a data protection officer, and this is generally the case where there is large volumes of processing of sensitive data, or you have regular and systematic monitoring of data subjects. A DPO will ensure compliance, facilitate capacity building of staff, so undertake training courses and going around and ensuring everyone is familiar with the Act. They might be conducting impact assessments as and when necessary, and they become your liaison officer with the ODPC. So if there is a breach, they're the ones who report it, or if there's an investigation, they're the ones who will be the liaison with the ODPC. The DPO space is fairly new. At the moment, very large organizations have DPOs, so like banks, insurance companies. Zamara has a DPO. But more and more organizations will need DPOs as the Act and everything it brings evolves. Now, I'd like to bring you to the principles of data protection. There was a myth that, data protection will mean that we need to go around and start getting consent from everyone and we'll have to stop processing data, but not really. We will need to process data, and we will want our data to be processed. We want our children's data to be processed so that they can go to school or that they can get health services as and when necessary. We all want to travel. For this, the travel companies will need our data. But what the Act is saying, that there are certain principles that we need to adhere to. The first one, and probably the most important, is that data needs to be processed lawfully, fairly, and transparently. This means for that every piece of data that you process, there has to be a lawful basis for doing so. And I'll take you through some of the bases that could apply. You must obtain the data without deceiving the person whose data it is. And you need to make it quite clear how you're going to use this data. It has to be fairly transparent. Purpose limitation. You should only use the data for the purpose for which it has been given to you. Right? We give data to companies when we buy goods and services, and then suddenly we start receiving marketing messages. So this means that they're going beyond the purpose, and that is not allowed. Data minimization. We should only ask for the data that we require. Let's not ask for blood groups when we don't need them, or postal addresses when we've actually stopped sending post. So it's time for us to relook at our forms, the data we capture of our employees, because once we have the data, the onus is on us to make sure that we're taking care of it. So ask for as little data as you need. You must ensure that any personal data you hold is accurate and up to date. And if someone has updated one piece of data, then make sure that this is updated across the board. And you also need to be accountable. You need to demonstrate that you take responsibility for how you look after the data, right? You might have a privacy notice in place, but this needs to make sure that you need to make sure that what's in policy is also being applied in practice. Storage limitation, and this is a really tricky one. What the Act says is that you must not keep data for longer than you need it, right? But you do need to keep data often, and it's important that you capture the length of time in your retention policy. So having a data protection and retention policy is advisable. And also indicating in your privacy notice how long you'll be keeping this data for. And last but not least at all is integrity and confidentiality. You must keep the personal data safe so that it doesn't get deleted or changed or seen by someone who shouldn't see it. And you must keep it confidential. So within your organization, if only one department needs access to the data, then there has to be controls. Other departments should not be able to access this data. I talked about the lawful basis, right? And initially, a lot of the advice that was obtained was that you need to get consent for processing each piece of data. And that might not be the case, actually. There could be other bases that you could use to process the data. Performance of a contract is one of those, right? All of us sitting in this room here have a contract with Zamara. We are employees of Zamara. And by virtue of that contract, Zamara processes some of our data in order to get us our employee benefits, our insurances, our pension. And then it also has a legal obligation to give some of this data to send it out to the statutory bodies like KRA, NSSF, NHIF, NITA. Sometimes you process data because it's in the vital interest of the data subject, right? It's a matter of literally life and death that you need to go into their wallet and pick out someone's card so that you can contact their next of kin. Sometimes it's of public interest or a public authority. You know, the courts have asked you to process certain data. A basis that is often used is also legitimate interest. So as a data controller, you have a legitimate interest to process this data, but you need to make sure that you're able to prove this if you ever get audited. You could be processing data for research, historic or scientific, but often you need to try and make sure that this data is anonymized appropriately. So your last port of call is probably consent. And consent would come in when, say, you want to send out marketing materials, etc. And with consent, what you need to remember is you need to be able to prove that you got that consent. So if it was, and it should be written as much as is possible. Having those records is vital, but also remembering that as much as someone can give you consent, they can withdraw that consent. And you should have the ability to allow someone to withdraw it, because there have been fines in the past where someone has withdrawn consent for marketing messages. That company didn't apply that withdrawal. They carried on sending marketing messages, and that company got fined 5 million shillings. The Act has done one thing which has been great for individuals, you and me again. It's given us a lot of rights. And like Jane Lucy said, a lot of these rights actually stem from our Constitution. But this means that organizations need to be ready, that people will be exercising these rights, and we need to have the processes in place for this. Individuals can ask to be informed why their data has been used. They can come and ask for their data. And there was recently a case where someone had applied for a job, and based on some data that the company had received from a previous employer, they rescinded an offer. And it was the individual's right to understand what data they had obtained, because at the end of the day, that was his data. You can object to processing some or part of your data, and you can correct and delete this data. When it comes to, you can move your data as well. So say you're moving from one doctor to another, you have the right to move that data. And organizations are not allowed, are meant to give that data within a very short time. I think it's about 2 weeks. And they're not meant to charge the individuals more than the cost of, say, the photocopying. We're now going to be moving into how to comply with the Act. I'd like to invite my colleague Amit Kadia. If you give me a minute while we'll do the swap over, he will take you through how to comply with the Act and what you need to be aware of.
Morning, everyone. I hope you can hear me. Great. Let me just share my slides. Right, so let's start with how do you start compliance? First of all, my name is Amit Kadia. I'm a consultant and a global privacy officer. I work with Zamara as a consultancy basis. So my job today will be to take you through what is compliance. I'll just share my slides. First of all, let's start with how do you need to start with your compliance? So it's all very good. We are saying, okay, we're going to be complying with the principles, the lawful basis. We are going to be, we have our contracts in place. And now there comes a time that now you have to start actually demonstrating compliance. Now, the global data protection is all about demonstrating compliance and how you are going to be managing your data protection on a daily basis. So, for example, if there is an audit, you will be asked for several documents which need to be implemented and need to demonstrate that you have complied with those. So first and foremost, I have seen many organizations when they start their compliance is we've got consent documents, as Shruti alluded to earlier. We've got privacy notice, and we are registered with the Office of the Data Protection Commissioner, so we are compliant. So my first question to them would be, where are your data maps? The data maps are akin to what in your finance department, they will call it as your bookkeeping documents or your accounting documents. So for example, if you have to demonstrate to the KRA that you're comfortable or you're filing your tax returns, you are doing your accounts, you need to show them your books of accounts, your expenses, your the income. And this is precisely what data map does to you. It's like it does for your organization. Basically, it gives very deep insight as to how data has been processed and eventually how it is destroyed. So how do you start data mapping? So the first step would be to ensure you either you get a software or you have a robust spreadsheet. So you need to start by saying what categories. First of all, you need to go not only organizational wise, but you need to go departmental wise. So for example, if most organizations have a finance department, HR, marketing, admin, some of them have kitchen departments, for example, if you're in a hospitality business. That gives you a starting point, and then you say what categories of personal data we process. So when you start doing the categories of personal data, one of the things I'll tell you what mistakes to avoid. So many organizations start lumping personal data categories in one cell. So for example, when you do the spreadsheet, so for example, they say we process gender, name, phone number, email addresses. That's fine. But then you need to make sure you have them separately. You do not need to make sure because one of the key areas you need to understand is the area of sensitive personal data. For example, your gender, the property details, race, tribe, social origin, your sex or sexual orientation. Those are all sensitive personal data. So if you are processing any of that data, those are known as sensitive personal data, and they must be kept separate in a data map. Then, what are the categories of the data subjects or the individuals? So the categories of individuals normally, say for example, employees, customers, suppliers or vendors, any other individual whose data your organization collects. So you need to identify that. So if you are processing an email address or a phone number, is it for an individual? Which individual is that? And the next step is who are you sharing the data with? As Shruti alluded to earlier, and Jane Lucy, one of the key areas of data protection is whether you're a data controller or a data processor. So you need to identify, for example, within your organization, are you data controller or a processor or both? And then who are you sharing data with? So if you're sharing data with, say, KRA, yes, that's fine, because if you're a finance organization, finance department, you need to pay taxes for your employees, and then you share the data with them. Then the next step would be, what is your lawful basis? So if you do not have a lawful basis, which was stated earlier by both my colleagues, you cannot process personal data. So there are 8 bases, lawful bases. You need to identify within those which category you fall. And that's in that way you actually go through step by step for each individual data subject and each category of personal data to identify what you are going to be processing. Okay. And data mapping is one of the most, I would say, difficult tasks. It's not difficult, I think it's not the right terminology. It is time consuming, right? But once done right, I can assure you it will give you answers to 70% of your organization's compliance with data protection rules. The next step is, how are you upholding data protection principles? Now, as alluded to earlier, stated by my colleagues, there are principles of accuracy, data minimization, and there are many other principles of data protection principles, which you must ensure that you adhere to. It must be stated in your privacy notices. So once you have got your documentation in place, your consultants will be able to identify, once you do a data protection project, as to what data are collecting. So let's say, for example, if we are collecting data for recruitment and employees. For example, I've seen many organizations on the HR, from the HR departments, they collect a lot of excessive data for when they're recruiting. So my question is, why do you need to collect somebody's family details or blood group, or even, for example, the property details when you are just shortlisting the applicants, right? By all means, you can collect if you need to collect the data when they become your employees. But if they are not yet your employees, why do you need to collect that data? So that's the principle of data minimization. Principles of accuracy, you need to ensure that whatever data you're collecting is accurate. For example, my name is Amit Kadia, but that is not what it states on my ID. But then you will realize that eventually when you come to the data subject right access request, you will need to identify the individual. Now, you can imagine that if you do not collect accurately, if somebody, there's some common surnames, for example, John Karanja, there might be several John Karanjas. There are several John Karanjas within Kenya. So how are you going to identify them, right? So you need to make sure that you keep your data accurate. Similarly, you need to adhere to the other principles of data protection to ensure that you demonstrate compliance on a regular basis. Coming to policies, privacy, and the retention. So there are certain policies which are mandatory. All of us, when we go onto websites, we sign up to apps on our mobile phones, you will see there are certain areas which are mandatory. So for example, when you are the terms and conditions you need to accept when you're signing up. And then there is another box you usually need to check is the privacy notice. That you have actually gone through the privacy notice and you're accepting the privacy notice. The privacy notice is one of the most misconceived documents, which I've seen many organizations just copy and paste. However, the privacy notice is basically your overarching notice to the world at large, how you are processing their personal data, right? And then there is the privacy policy, which is an internal document, which is a notice to your employees and your internal stakeholders, how you are processing their personal data. So doing a data map is very, very important to come up with a very accurate privacy notice, because whatever you state in the privacy notice, you will be questioned on it in future as to how are you now adhering to data subject rights, principles of data protection, lawful basis, how long are you retaining, who you are sharing data with. So there's a whole host of compliances. So within your organization, if you are doing any form of copy pasting, or if you have somebody doing the copy pasting or privacy notices, I would recommend that to revisit. This is a very important document. Retention, this is a very unique area to our data protection in that our data protection regulations specifically say that you need to have data retention schedules. This is unlike the general data protection regulation, where it is not explicitly stated, but it is one of the principles of data protection in Kenya and under the GDPR. But under our Kenya Data Protection Act, data retention is specifically mentioned. So just like that, you also under the Data Protection Act in Kenya, you do need to have mandatory data retention schedules. You also are required to have the data retention policy, and then you need to demonstrate how you are going to be complying with the first principle of data protection is lawful, fair, and transparent. How are you processing data in adherence to that first principle of lawful, fairness, and transparency? So then moving on to procedures. In this age, we have seen there have been, in the last 6 months, there have been a number of data breaches in Kenya. So some of them have been some very prominent organizations, ranging from telecommunication companies, supermarkets. There have been data breaches. So you need to have a data breach procedure in place. So who are you going to contact? How are you going to identify when there is a data breach? How do you contain the data breach? How long do you have to respond to the data breach? Who is going to be responsible? Is it the controller, the processor? You need to have a data controller, data processor agreement in place, which identifies who will be responsible for the breaches. You also need to have a data subject access requests, the procedure in place. This is going to be one of your biggest headaches, I can assure you, in the coming years, because every data subject, yourself, myself, all other data subjects have a right of access to their data protection, to their personal data. What this means is that once you get a data subject access request, so this can be the right to access, right to rectify, right to object, right to the right to delete, right to restrict. These are the data subject rights. And there are very finite timelines within which you need to respond. Usually within 7 to 14 days in the general data, in the Kenya Data Protection Act. Under the general data protection regulation, is usually 30 days. Okay. And unfortunately, there is no time for extension for data subject access requests. So you need to make sure that your organization have a data subject access request procedures in place. Because if they're not in place, then you do need to make sure it actually does give rise to a complaint to the ODPC's office. Reviewing third-party contracts. So I have seen, again, this is one of the to-dos and do's and don'ts in a data protection contracts. So I have seen many organizations, they say we've got a data protection clause in our contract. And that is one of the things which annoys me. Why? It's because you cannot just have a clause in a contract and say that we are compliant. No, it's absolutely not correct. What the Data Protection Act states that if you are a controller or a processor, you must ensure that you vet your processor, so whoever you're sharing data with and third parties, and they adopt the same standard of technical and organizational measures you have in place for protection of personal data. Because if you are a controller, for example, if you are a Zamar, and you are sharing a data set, for example, with an insurance company or another bank, and they become your processors, hypothetically speaking, if there is a data breach on the side of the processors, usually the responsibility for that breach lies on the side of the controller, not of the processor. Again, it depends on the circumstances, but I said usually it does depend. So then, for example, in this example, Zamar will be responsible for the data breach. So what happens is that you've got an agreement, you've not vetted the person, the organization as a processor, you don't know what security measures they have in place, whether they have encryptions, password policies in place, you have started sharing data with them, and then there is a breach, right? What happens? ODPC comes for an audit, and you say we have an agreement, right? Good. Now, did you vet them? Are they compliant? So make sure you vet. That's a precursor to the contract. And whenever you have a data protection clause in your agreements, make sure that is sufficiently backed up by what is on the ground. Next, we go to security measures. So these are normally known as technical and organizational measures. So first of all, just by being here, all of you are demonstrating one of the key areas of technical measures, which is training and attending webinars, and to be constantly aware of what data protection is and getting experts to speak. So the technical organization measures simply mean, for example, in the technical measures is, are you training? What sort of, do you have a password management policy in place? Do you have multi-factor authentication in place? This is on the IT side. Some of the largest organizations I've worked with within Kenya and globally don't have some of the most basic security in place. So for example, when I do my site audits, there's a lot of paper lying around, and then I find lovely cabinets, brand new, with nice locks on them with the key there. So I said, what is the key doing on the lock, and why is the paper outside, right? So these are just some of the things you need to keep your paper on the lock and key. It's as simple as that. Password change management. I mean, some of the most basic softwares, right? Whatever software you're using, it actually gives you prompts to change your password change management, password change, right? I mean, mine does, and I probably pay less than most of you. So you need to make sure your password change management policy in place. Your employees must be trained. Employees are usually 96% to 97% cause of data breaches. However, if employees are not trained, how are they meant to know what is a data breach? What is a phishing email? What are the data subject rights? Okay, and then so it starts from the top. So the data protection, essentially, if you talk about roadmap to compliance, the first thing, which I should have mentioned, that there has to be support from the top management. If the top management, the top brass, the board of directors do not buy into privacy, what are the employees meant to do? So it's very important that if you are board of directors or the CEO, you need to buy into that. Just to mention, one of the things which I read the other day is, if those who have started implementing data protection within their organizations early enough, for example, under the General Data Protection Regulation, this was way back in May 2018, they are actually seeing the return on their investment twice, so 2 times the value. There's a report by Cisco, and I'll be happy to share with you. It's online as well, which gives you a whole load of matrix, how they came to that conclusion, and they across North America and Europe, I think they did surveys more than 2,500 organizations, right? So for those who are, at the board level, you will find also a return on your investment in privacy. So that's one thing I wanted to mention. Coming to the registration with the ODPC, you need to ensure that you are registered with the ODPC if you meet the threshold. So the threshold is 10 employees or turnover of 5 million Kenyan shillings in the preceding financial year. If not, and so for example, it's not cumulative. So if you meet 10, the threshold, if you have 10 employees, you do not have a turnover of 5 million, you still need to register. So, but if you have a turnover of 5 million, you do not have 10 employees, you still need to register. So it is either or. Okay, but then at the same time, there are also under the second schedule of the Data Protection Regulations, 2021, registration regulations, there are certain key industries, sectors, who must register if they are carrying out, for example, the hospitality business, hospitals, banks, insurance companies, telecommunication companies. You must register irrespective of your turnover. And I think I did mention training earlier. So training, as I said, is one of the very key parts of roadmap to compliance. Training, in my opinion, again, depending on the nature and size of your organization, because data protection is a very new space, you need to ensure that you have regular trainings with your employees, the board members, and it has to be bespoke. So for example, if you are training employees, if they are within the HR department, you need to bring HR elements into it and make sure it's about them. If you are training the board of directors, make sure it's the board of directors understand you really do not need to give them the nuts and bolts. So for example, you need to give them how privacy is going to assist them in increasing shareholder value, reputation, and trust with their organizations. Okay, so training needs to be tailor-made. It can be generic, but it can also be tailor-made. Great. I think that's I think I've said everything, Shruti. Yeah, unless there's anything I've missed on.
I think that's fine. I think you've covered the data mapping as well.
Yes.
And then, sorry, the one thing, I don't know if you just want to briefly talk about breaches.
Yes. So I mentioned breaches earlier, and if your organizations are just starting your compliance journey, we hear of hackings every day, right? Cybersecurity breaches. So the first area you need to train your employees and the management is on how to identify data breaches and what to do when there is a breach. So now, if you are a data controller, you need to report to the Office of the Data Protection Commissioner within 72 hours of becoming aware of the breach. Not all data breaches are required to be reported to the ODPC's office, so only serious breaches. And so let me give you an example. So if you are an organization and you have and you send an email and you send it, instead of doing a blind copy, you do a CC to someone, say about 100 recipients, and that just contains some informative materials. It does not contain any personal data. That is still a data breach. Why? Because you have actually exposed 100 people's email addresses to those who did not require it. However, if you do again a CC and it contains sensitive information, for example, health information or financial information, that will amount to a serious data breach. So you need to identify that is this really a serious data breach or is it not a serious data breach? And that is when you report to the ODPC's office. Under the General Data Protection Regulations, this is in General Regulations, I think it's Schedule 3. There's a full list of mandatory data breaches which must be reported to the ODPC, irrespective of how serious it might be or not be. So I recommend you go through that. So controller needs to inform the ODPC, and if you're a processor, you need to inform your controller within 48 hours of becoming aware of that breach. You also need to notify the individual whose data you're processing within a reasonable period of time, unless the data subject cannot be identified or established. In which case, if they cannot be established, you may wish to consider even having a public notification that there has been a data breach. Okay. How to deal with data breaches? First of all, you identify data breach. Not all data breaches, not all breaches, not all data breaches. Some may just be an incident. So, but one of the key areas you need to identify is, for example, even if a person or an organization or a hacker has access to your data, and if it's sensitive data, that is still a breach. They do not have to have tampered or extrapolated it in any way. It is still a breach. So I would suggest go through the whole definition of what is a data breach. So it can even be an access, even if it's for a few minutes. The next step, contain the breach. So I always give the example, when you see a fire, you just don't sit there and say, okay, let's just pray the fire goes away. No, you need to contain the breach. You need to get buckets of water, sand, call the fire brigade. Same with a data breach. What do? Get your, change your passwords, right? Get your cybersecurity professionals in place. Do whatever you can within your own capacity to see if you can contain it. Call the data protection, the DPO's office, right? Notify them. Assess the risk. Now, this is when you need to make a decision. Do you need to really report to the ODPC's office once you've assessed what risk it has posed to the data, to the individual? And then consider breach notification and convene a response team. Then finally, how did the incident happen? Was it a phishing email? Was it lack of training? Was it some super hacker? Are your IT systems weak? You know, some of those things you need to look at and then take action to prevent future breaches. And finally, I would also recommend is have a data breach drill. I always call it a data breach drill is because just like a fire, the data breach can have just as grave consequences if not handled properly. So you review make sure you do, like, for example, just hypothetical drills on a regular basis, and then take the action to see how it can be prevented. Okay, I think that's that. Yeah, and now be prepared. I think, and the be prepared section is, as I said, you need to register with the ODPC. The ODPC is likely to audit you, maybe not in a month, 2 months, maybe 2 years, 5 years, who knows, right? But you are likely to get an audit. When you get an audit, how are you going to respond to it? What documents are they likely to ask for? How are they going to look at your organization? So you need to have that in place. Data breach, I think I've spoken sufficiently about that. And data subject request access. I think I've already spoken about that. The main thing also I wish to say about data subject access request, there are exceptions. So you do not need to have, for example, if I ask you for my data, you do not need to supply me with the data if there are exceptions. Okay, so for example, if you are going to be, if it's against the law, if you are going to be, is going to be invasive to somebody else's privacy, if there's a court decision or there's a legal obligation not to provide that data subject access request, then you need to, you're not mandated to give that data, okay, to the data subject access request. Contracts, I already said sufficiently about this earlier. Say for the fact that you do need to make sure that how these contracts are drafted is very key. More importantly, as I said, I've seen a number of organizations who will that once they've signed the agreement, it says data protection clauses are protected. No, this is absolutely not correct. The precursor to that, you need to make sure you need to get your the third party, the vendors, the processes vetted. Are they really compliant? Are they registered? Have they got their policies in place? How do they use sub-processors, right? So these are some of the key areas you need to look at. Yeah.
Cool. Thank you. Thank you very much, Amit. We've already been getting some questions. So I think, oh yeah, there's this, I mean, obviously there are consequences of non-compliance. Amit, I don't know if you want to quickly touch on it. I'm also conscious of time.
I mean,
We
I'm
have
not,
20 minutes
sure.
and we've already, yeah.
Sure. Thank you, Shani. Thank you, Shruti. I am not actually a big proponent of enforcement, because enforcement and penalties should not come in. And I can see all of you who are here are serious about it, data protection. But in the worst case scenario, if there is a non-compliance, and one of the key areas of non-compliance is registration with ODPC. So first of all, today when you go from here, do a small assessment and see, do you need to register with ODPC? If you are not, give that a priority. Because rest assured, if you're required to register, the registration started last July. If you're not registered, then that is a compliance issue, and it is likely to be an automatic fine. Okay, so you need to look at that first. But however, if in case of any other non-compliance issues, the fine is 5 million Kenya shillings, or an imprisonment of 2 years or both. Okay, or there is the penalty notice. For example, this is an administrative penalty. A law of Kenya is 5 million, or 1% of the annual gross turnover. There are other mechanisms. You know, for example, if you are given a penalty notice, you can get it reviewed by the ODPC's office. You can go to the court to review it. However, you need to have very strong evidence, right? I mean, you can't go there and say, look, we started the registration process, but we forgot about it, so we don't want the fines, right? Something like that, you need to be very careful. There have been a number of fines recently in Kenya in the last 1 year. So, for example, these are well-known names: Oppo, there's the telecommunication company, Regis, WhitePath. And to be very brief, Oppo was fined because they were not registered. They simply refused to comply. Regis was fined because they were not complying with direct marketing. They did not seek consent when they were sending direct marketing messages. WhitePath, I think it was a similar issue, that they were not non-compliant. I think they were not even registered. So these are some of the largest fines. Safaricom, I think there is an issue going on. There was the hospitals. There's well-known hospital in Kenya. There was an enforcement notice, and the fintech companies were fined. Well, they're not fined, but then an enforcement notice was issued, and I think their license was also revoked by the central bank, right? So out of those 40, to my knowledge, I think over 50% have complied, and the rest have not. Yeah, so these are some of the key areas. Yeah, and I think I will leave that now for Shruti to state how Zamara can be of help. Over to you, Shruti.
Thank you, Amit. So, I mean, I want to quickly go through this because I want to have at least 10 minutes for Q&A. But Zamara is helping organizations with various aspects of data protection. So from data mapping to gap analysis. So for the data mapping is we help you conduct your full data audit. If there are any gaps, we can identify these and provide recommendations. We can help you draft a privacy notice, both for your clients and even for your staff, because you're probably aware employee privacy is a brewing issue. We can help you draft your data protection and retention policy, processes for your breaches and data subject requests, help review your third-party contracts to ensure that they are compliant with the Act and your third-party providers are also complying. We can provide training, and we can assist you with the registration with the ODPC. We are also providing for entities that have started or they feel like they've completed their data protection journey. We can conduct an audit to help ensure that you're fully compliant. And if there's any gaps, we can help you, identify those gaps and provide recommendations on how to fill those gaps. What I will do is we will send these across to anyone who's interested. I will leave my email address as well in the chat box. There's something that we're also offering in October that we're quite excited about. It's data protection officer training. As I mentioned earlier, there's not very many data protection officers in Kenya, and even the ones that are, there's not been as much training available. So Amit, who spoke earlier, is a qualified and certified trainer globally, and I think the only one this side of the world. So this training is going to happen 12th and 13th of October in our new training room at our new offices. I would like to also introduce a privacy software, but in the meantime, we can start with some questions and answers as I pull that information across. And I think there's already some questions in the chat box. But if there's anyone else who has questions, you can put your hand up.
All right, I realized we had Elizabeth on the call who had put her hand from earlier on. So Elizabeth, you can go ahead and unmute yourself. Maybe while Elizabeth puts the question on the chat box, we can go through some that have not been responded to yet. And Philip Nungu asks, is the DPA supposed to be the guiding document on data policy formulation? If not, what are the key components of a data protection policy?
Yeah, I'll take the question. Thank you, Philip. Good question. First of all, data protection policy.
Check that?
Yes, thank you. I'll take that. Philip, thank you for the question. First of all, data protection policy is a mandatory document required by the Data Protection Act. The Data Protection Act is a guiding document in that you need to include in your Data Protection Act what are the principles of data protection, what are the lawful basis, what are data subject access requests, and there is a whole host of requirements you need to put in the data protection policy. Unfortunately, we don't have time for going into what are the key components at the moment, but we will be covering that in that training, which will be just mentioned to you, which is upcoming. Say for the fact that this is an overarching policy, right, which assists your organization to comply. And apart from this data protection policy, there are a number of other policies you also need to have in place. So for example, one of the areas I mentioned is one of the policies I mentioned is a privacy policy and a data privacy notice, which will be, which also complies with the DPA. Right? Does that answer your question for now?
Elizabeth, I don't know if you want to try unmuting yourself.
Looks like Elizabeth is still struggling to unmute herself.
Hello?
Bella, go ahead.
Yes, hi. Can you hear me?
Yes.
Fantastic. Thank you very much for that informative presentation and session. I just have a question about what are the gaps or the differences in approach between our national legislation, data protection, and the EU GDPR, maybe just in a point form. Probably you covered this before I joined the meeting, and I apologize if you did. Thank you.
Thank you. Thank you. I'll take that if it's okay with you. Bella, that's a good question. Again, as I said, I can do a full course on that. However, there are a very number of differences. First of all, to start with, our Data Protection Act is modeled heavily on the General Data Protection Regulation. However, when many organizations state that we are GDPR compliant, and so we are also Kenya Data Protection Act compliant, that is incorrect, because you need to make sure you are compliant. If you are going to process Kenya's data, you need to be compliant with Kenya. Now, having said that, there are a number of nuances between both. One is there is a principle of the family details. For example, under section, I think it's section 19 of the Data Protection Act, no, so 20, yeah, 19 or 25, I don't remember correctly. So one of the principles is that when you take family details, you need to make sure that you process it as per the principle of data protection and you have a lawful basis for it. That is not stated in the GDPR. The GDPR is very heavy on children's rights. Ours is not as yet. We do expect, hopefully, the ODPC to issue some guidelines on that in the future. Two, the data protection officer, there is an explicit provision that they must not conflict with any of their other rights, any of the other roles and responsibilities. That is not stated under the GDPR, but there have been numerous cases in the German Data Protection Supervisory Authority. There's been, I think, one in France as well. They've issued guidances that there should not be conflict of interest. Three, our Data Protection Act specifically says there has to be data retention schedules maintained, and this is explicit. Under the GDPR, that is not a requirement. However, under the principle of purpose storage limitation, that is implicit. So that is one of those are the three areas. There are also other areas, for example, when you must have a data protection policy in place that is not under the GDPR. And then there are also, for example, when you need to notify breaches, they have explicitly been stated in the third schedule, the areas where there are breaches, you need to be stated. Registration is not mandatory under the GDPR, under Kenya Data Protection is. So, I mean, these are just some of the 5 high-level areas. I mean, I could probably tell you many more, but these are some of the 5 areas you probably need to be careful about. Yeah, does that answer your question?
Yes, maybe just a follow-up. In terms of free flow of data in Kenya and outside, I know that the GDPR has very strict measures in terms of if any personal data is getting out of Europe to or a European Economic Area to another geographical location, there are some strict measures like derogations and safeguards and stuff like that. Yeah. Do we have that in our law?
Now, that's again a very broad question, and I've written a number of articles on that. So I think, I mean, just to answer your question very quickly, it is very similar, right? But then there are some differences. What I'll do best thing is, Bella, if you can send me an email, I'll be happy to share with you my article which I've published. It will give you a very comprehensive answer.
Thank you. Thank you very much. Yeah. All right.
Right, Bella, we could have Angela go next. In the meantime, in the interest of time, we are having questions on the chat box being answered simultaneously. So keep posting there while we hear from Angela.
Ahmed, there's a question here. When a staff exits an organization, should any information related to them that has been shared publicly, for example, websites be pulled down?
Now, once the employee leaves the organization, first of all, as I said, you need to maintain the data retention schedules. Okay. And then your second question states, even if there is no legal basis to keep the data but regulatory, what happens in the event if an employee asks that their personal data to be done away with their leave? You've answered your own question, Nancy. So if you have a legal basis, an employee leaves, you need to rely on the lawful basis of legal obligation. You cannot delete that data. So for example, if you need to keep it for NHIF, NSSF, KRA purposes, you can keep that data, right? But of course, you need to have a finite period, you know, how many years, how many months you're going to keep it for. Does that answer your question?
Thank you, Ahmed. So I know we still have some questions, but we need to close this session. I will be putting my email address in the chat box. So if you have further questions, and I know there's a few there. We're going to aim to at least respond to those. But if you've got other questions, please drop me an email. We'll see how we can help. There's one thing that we just wanted to share with you, is there's privacy softwares now available, and they can help you with, a bunch of things. This is a fairly detailed document, which I can share with anyone who's interested, but it can essentially help you with your privacy journey. So it can help you with things like, keeping a log of your breaches, data subject requests. It can help you respond to them and keep a log of them. Consent management as well, because like we mentioned, as much as you can get consent, you're meant to make sure you have the records and ability to also withdraw that consent as well. So it's got lots of different features, and it has been catered to the KDPA. So if you're interested in a demo, then we can arrange the same. I will share further details with everyone who's registered. When we share information, we'll share the slides. We'll also share some of the information about surrounding the services that we provide in this space. So I think that's it from us. Thank you very much for being a very engaging audience. It's the questions have been very interesting. So thank you so much, and have a lovely day. Amit, I don't know if you have any closing remarks, or Amos.
Yeah, thank you for having me, and I think this has been a very insightful audience. And if you have any questions, shoot us an email, and we'll be happy to answer.
So it's definitely an ongoing conversation. Feel free to reach us through the many channels you have. We are happy to engage you further. As you are aware, we are planning trainings, and we'll continue to share that information with you so that you can register and take advantage of the same. Otherwise, thank you so much for the 145 plus of you who joined the conversation. I believe this has been very exciting. Look forward to the next. And my colleague Shruti has put her email on the chat box. Feel free to write to her. Like we said, we are happy to respond to any other areas of clarification. And of course, we'll be giving you bits and pieces of information related to the data protection through the email addresses we have for those who registered. Thank you very much. We wish you a great rest of the day and look forward to more engagements from us.
Thank you. Bye.